Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Morning. Our next case is Vanguard Pai, LLC et al. Versus Moody et al. We will hear from the appellant.
May it please the court. My name is Preston Odom of the Mecklenburg County Bar, practice with James McElroy and Deal in Charlotte. And I'm here this morning representing my three clients, Bill Moody, who is seated in the audience, and two North Carolina companies that Mr. Moody is the principal in, Nova Trading and Nova Wingate. I'd like to reserve 5 minutes of time for rebuttal, if I may. Your Honors, this lawsuit began back in 2018, a couple months after Mr. Moody was removed as the chief executive officer of Vanguard Pai, which is one of the two plaintiffs in this case. The other plaintiff in the case is Pai, which is a Taiwanese company headed by James Wang. The case proceeded through the various stages and ended with a trial that took place in March of 2022, at the conclusion of which the jury entered a verdict against my clients, Mr. Moody, together with Nova Trading and Nova Wingate on some claims for millions of dollars. The claims ranged from unjust enrichment, fraud, conversion, embezzlement, punitive damages, and I got involved after the trial had occurred, but helped with the post-trial motions after the judgment was entered. And we have appealed from three aspects of the corrected judgment that Judge Conrad entered, along with his Rule 50 and 59 order, and also the denial of Nova Trading's motion to dissolve Vanguard Pai. Those three aspects of the judgment and the Rule 50 and 59 order are dealing with three claims: the fraud claim, the conversion claim, and the embezzlement claim. The fraud claim was with respect to the jury awarded damages of $498,500. And it was based on alleged misrepresentations made at the outset of the formation of Vanguard Pai back in 2009. The operating agreement reflects that Nova Trading, as its initial capital contribution, was contributing all of its assets except for some cash and accounts receivable, and was deemed to be of a value of $500,000. There was testimony at the trial by Mr. Moody that those assets, which were some spare parts and used knitting machines that could then be either refurbished or used to sell to other businesses that had these circular knitting machines, that was well above $500,000. There was testimony presented that 12 years later that those machines weren't valued, it didn't have that value in the beginning. There was also a claim that Mr. Moody misrepresented that there would be an appraisal of the equipment that was contributed as part of the initial capital contribution. My predecessor, trial counsel, made a motion for directed verdict at the close of the plaintiff's evidence, at the close of his evidence, or the defendant's evidence, and then at the close of the rebuttal. challenging what we contend is the fraudulent intent aspect of the fraud claim.
In a business court case like this, I would have expected to see a written motion for directed verdict filed. That seems to be what typically happens, so that you can spell out, because of the requirement that you have to be so precise in the basis. But that didn't happen here. I think we're going to hear from your friend that that's a problem for you procedurally. What's your position on that?
Yes, Your Honor. We agree in our brief that it wasn't the model of clarity, the directed verdict motion that was made orally at during the trial. But we contend, giving a broad reading of the arguments made in conjunction with prior context leading up to the trial, especially with respect to the conversion and embezzlement claims, but that when my predecessor trial counsel mentioned the element of intent, that he was challenging the fraudulent intent aspect of the fraud claim. And I believe my friend is going to argue that really it just related to whether there was an intent to have an appraisal done, and not whether there was an intent to allegedly misrepresent the value of the equipment that was contributed. But we contend that it was broad enough to cover both of the alleged misrepresentations, and based on the context. But I agree with Your Honor that I think typically there would have been a written motion, or at least a trial brief at the beginning that would have spelled out the contentions on the various points in the claims. And so, Your Honor, in good faith, we believe that there is enough there to make the arguments that we've made, and we really have taken a rifle approach on both the post-trial motions and on appeal, and not tried to shoehorn in other things that clearly aren't within the scope of the DV arguments. But we contend that with respect to the intent, that it was broad enough to make the arguments that we've made in our brief. And with respect to those particular arguments, with respect to the value of the contributed assets, the parties deemed that it was at least $500,000 in the operating, or yes, in the operating agreement. And so if we had wanted to stretch, would have made the argument that there couldn't be reasonable reliance on an intent to appraise, because the parties had deemed the value to be $500,000 back in 2009. But we haven't made the reasonable reliance argument because that clearly wasn't presented at the DV level. Also, Your Honor, it seemed like the plaintiffs shifted course a little bit during the trial as far as the appraisal aspect. It looked, in reading the transcript, that they were riding the horse of that the operating agreement required an appraisal if there was a contribution of assets and not cash. But that fell flat at trial because the contributing person was Nova Trading and not a manager, which was Mr. Moody was a manager, Nova Trading wasn't. And so the specific appraisal requirement of the operating agreement didn't apply because it wasn't a manager that was contributing the property. It was a member, as defined under the operating agreement. And so, Your Honor, we contend that there's not anything more than speculation, conjecture, or surmise, i.e. not a scintilla of evidence to support that Mr. Moody had an intent to misrepresent the value of the contributed assets, or to ultimately have an appraisal. There's no mechanism in the operating agreement. Let's say the appraisal came back and it was $750,000. There wasn't a mechanism under the operating agreement to say, well, you've contributed actually more and you should get more of a membership percentage based on that excess value. And just as if it had come back at $495,000, there wasn't any formula or anything in the operating agreement to adjust for that. And so the parties treated it as a $500,000 initial capital contribution. And we don't believe, based on the record presented, that there was a scintilla of evidence of fraudulent intent on that claim. The next claim that we're challenging in two respects is the conversion claim. And to have a conversion with respect to money or funds, under this court's variety wholesalers case, there needs to be evidence of specifics of where it came from, where it was going, what it was for. And Your Honor, based on the evidence presented at trial, particularly the plaintiff's own expert, John Gibson, and in the exhibits to Mr. Gibson's report that was admitted in that evidence, it lists some expenditures that were made, but we contend it's found on pages 295 through 298 of the documentary exhibits volume. We contend that under the variety wholesalers holding, that the expenditures that are listed in there with respect to Noreen Moody, who also is here in the audience with her husband Bill Moody, or with respect to unauthorized expenses, Carolina Panthers tickets, it says at the top, that that evidence is not sufficient to pass muster under the variety wholesalers case. And Justice Dietz, with respect to an issue preservation argument, they've also contended that my predecessor trial counsel did not raise the specifically identifiable funds requirement with respect to the conversion claim. But again, leading up to the trial, as well as at the trial, there was a lot of discussion about whether there should even be two claims versus just one, because of the overlap between the embezzlement and conversion claims. And again, it wasn't artfully stated at the DV argument, but we contend that when counsel raised the specifically identifiable funds requirement, that it was with respect to both the embezzlement and the conversion claim. And so we've alleged that basis in our briefing here to the court for both the embezzlement and the conversion claim.
And while they're there, let me
Yes, Your
follow up Justice Dietz' question. You make the argument that the objection was broad enough to include. My question is, should it not have been more specific so that the court could have dealt with it at the directed verdict stage? I believe there's a Court of Appeals case that's relied on heavily, Plasma Centers of America. How do you distinguish that from the situation here? I understand your argument about it being broad enough, but what about the specificity that was not there?
Yes, Justice Berenger. We contend that it was both general enough to cover both of those claims and specific enough based on the evidence that was presented, because let's take the conversion claim, for example. It adds up exactly to what the expenditures are listed in the expert report. So there was the $226,000, $226,500 plus the $5,500, plus a revision to the last page of his report, which was dealing with personal property not returned. He revised the amount of damages alleged on the personal property from $42,500 to $40,300. And then that adds up. You add those figures together, and that's exactly what the jury awarded on the conversion claim. And so when you're talking about the specifically identifiable funds requirement, then construed in light of the evidence that was presented, that's what it would have to relate to. And so it's specific enough to get to that. With respect to the embezzlement claim, not exactly sure where the jury got the $500,000 number. There was some damage categories that were listed in the expert report for allegedly overpayment of salaries to certain people, or to Norma Alexander or Thomas Alexander. There was some attorney's fees that were involved in that component. But so when counsel raised the specifically identifiable funds requirement of variety wholesalers, based on the context and the evidence that was presented, that's all it could relate to. And so we contend that that's sufficient to cover both claims, but also relate to the evidence presented to both of those claims. And so that's what we would contend distinguishes our case from the Plasma Court of Appeals decision. Another aspect with respect to the conversion claim is the Judge Conrad instructed the jury that it couldn't award any damages that arose outside of the three-year statute of limitations window, which was July the 8th of 2015. So anything that was prior to that would fall outside of the statute of limitations window. And if you look at, again, the evidence presented in plaintiff's own expert report, we've identified $111,000 in change from exhibits 4.1 and 4.2 that fall outside of that time period. And so that's an alternative challenge that we've made under Rule 59, that there needed to be a new trial on the conversion claim absent a remitter of that amount, because the jury necessarily would have had to have disregarded the trial court's instructions and they would have awarded damages that fell outside of that window. In my friend's brief, in the appellee's brief, they raised the notion that that $272,300 figure could have been relating to possible other expenditures. But again, it's speculation to make that argument, in my opinion. It's not, so we're not speculating that the jury used the figures from the expert's report because they match up exactly. And so to say, oh, it may have been expenditures for payments made to Norma Alexander, let's say. They're in Exhibit 7.1, there's $160,000 listed with respect to her, but $132,000 of that falls out of the statute of limitations window. And so we don't think that the damages on the conversion claim related to that, but if they did, then the 132 of that falls before July 18th of 2015. And so again, we think that at the very least, with respect to the conversion claim, that that there needs to be a remitter or a new trial with respect to that claim. On the embezzlement component, again, my friend points out there's no North Carolina decision that says that the variety wholesalers specifically identifiable funds requirement relates to an embezzlement claim. But the General Assembly chose to use the word convert in the prescription under the statute that gives rise to the civil claim for conversion. And so we contend that if it's a crime, you need to read it even more strictly, and the General Assembly is deemed to have legislated with the common law in mind. And so using the conversion terminology, we contend imports the specifically identifiable funds requirement into the embezzlement claim as well.
Well, I would like to explore that a bit, just as a practical matter, how you can identify funds, especially if there's an ongoing embezzlement out. It's one thing, you can embezzle a computer, you can steal, and that would be easy enough to identify. You've taken property. But when you're dealing with a fungible item, such as cash that's in a drawer or a bank account or various places, I mean, these people can be very creative in how they do their embezzlement, and it usually occurs over a number of years. And so I would like to explore with you how you think that if there were an identification requirement, how that would be applied and how as a practical matter, it would be useful.
Yes, Your Honor. I think in line with what the facts were in the variety wholesalers case, if you had a wire transfer, going from the business's account to an offshore account, and you could trace that wire transfer from point A to point B, and then those funds are still in there at point B or are traceable. It's almost like an inequitable distribution case in classifying whether something is marital or separate. There's some tracing components involved. And so I would say under the variety wholesalers case, that you could have specifically identifiable funds tracking them from point A to point B.
What would happen if the tracking somehow failed, or you mentioned that the funds were still in the account or still where they were? They have now been removed from whatever account and there's someone else. Does that mean the embezzlement claim fails, or how would that work?
Your Honor, I would say that it fails just as the conversion claim would fail. And so, yes, with respect to money specifically, I would say
Yes,
that that would fail.
And I'm asking specifically cash, money, whatever, currency of some type.
Right, Your Honor.
Because again, a computer or an item can be traced and identified. I guess tracing is not the word identified, whereas cash being more fungible would be more difficult and more obscure.
Right, Your Honor. And we think that there would be other potential claims that you could assert to get after that. So take, for instance, the unjust enrichment claim for $1,340,000 that my client or two of my clients were held liable for. That was for a lease agreement that there was $10,000 a month paid. And so that might be a way that you could go after those funds via an unjust enrichment claim versus conversion or embezzlement specifically. And so it wouldn't necessarily put that off limits. It just wouldn't make it subject to that claim, if that makes sense. And then, so lastly, so we've talked about the embezzlement claim. And the importance of that claim as well is both of the plaintiffs asserted a claim for attorney's fees with respect to the embezzlement claim because it allows for the potential recovery of that. Judge Conrad dealt with that by saying that plaintiff Pai Long could not assert it because it wasn't the owner of the alleged property at issue, that only the Vanguard plaintiff could assert it. And then also that the $2.6 million in fees that Vanguard was seeking was too much, but it didn't give parameters on what enough would be, but dismissed Vanguard's motion for attorney's fees without prejudice, but to potentially refile after appeals are exhausted. And so, but if the embezzlement claim goes away, then the possibility for recovery of attorney's fees goes away as well, because attorney's fees aren't awardable on any of the other claims at issue. And I'm getting close to the rebuttal time, but I wanted to mention we've also challenged the denial of Nova Trading's motion to dissolve Vanguard. And the last case before Your Honors was dealing with judicial dissolution of LLCs. We have alleged both grounds, the impracticability as well as protection of Nova Trading's interest in Vanguard. The impracticability, I think, is less important based on our factual background than protecting the interest of Nova Trading. We have obvious acrimony between the parties, and Mr. Moody's been accused of lots of wrongdoing, and there's been multiple $1 million in judgments entered against him and Vanguard and Nova Trading. And it's difficult to see how Vanguard could continue to operate with the best interest and a fiduciary duty owed to the 33% minority member when it's got multiple $1 million judgment seeking attorney's fees, and it's an international company. There's a Taiwanese company that's the majority member of Vanguard. And so we contend that Exhibit A to why the Vanguard needs to be dissolved is the jury verdict against the minority member and the minority member's owner. And I'll reserve the rest of my time for rebuttal unless any of the other justices have any questions.
Thank you, counsel.
Thank you.
Hear from the appellee.
Mr. Chief Justice, and may it please the court, Matthew Tilley with Womble Bond Dickinson for the appellees Vanguard Pai and Pai Machinery Mill Company. Defendants have not shown any basis to disturb the jury's verdict in this case, which was entered after a 6-day jury trial in which the jury heard extensive evidence concerning the defendant's misconduct and Mr. Moody's course of self-dealing used to benefit himself, companies he owned, and his family members as CEO and president of Vanguard. Although defendants contend that the business court should have granted their motion for judgment notwithstanding the verdict or a new trial, they present the same arguments that they presented to Judge Conrad in the business court below, in which he consistently rejected as meritless in a carefully reasoned 22-page decision that cites, and in numerous places, the evidence that supports the jury's verdict. Ultimately, the defendants' arguments were either waived or not preserved, or ignore the extensive evidence at trial, and this court should affirm for the same reasons in Judge Conrad's opinion. I'll address the 3 claims that they have challenged. First, the fraud claim. The central allegation of the fraud claim was that Mr. Moody induced Pai Long into entering into the agreement for Vanguard by promising that he would make a capital contribution that would be worth at least $500,000. It would be deemed $500,000 as a capital contribution in the contract, but it would be worth at least $500,000 worth of inventory and machinery that he had from his previous company. And he promised Mr. Wong that he would get an appraisal to back that up. Mr. Wong testified as to all of that. He testified that he later learned that those were lies. At trial, the directed verdict argument, which defendants say is not the model of clarity, is frankly barely intelligible, was directed at the intent to have the inventory appraised, one of the 2 prongs on which that fraud claim existed. It did not address the promise or the representation that the machines were of value and that they were in fact $500,000, worth at least $500,000 in value. On that basis, Judge Conrad found that the arguments had not been preserved and there had not been an argument, or excuse me, there was not a preservation of the argument that there was no showing of fraudulent intent. We agree with that, but Judge Conrad went further and he said, look, there's more than sufficient evidence to show fraudulent intent. Mr. Moody had, the testimony was that Mr. Moody had the machinery booked onto Vanguard's books at $500,000, and that he stored them in an off-site warehouse that was controlled by his company, with whom he had signed a self-dealing lease that he signed, this is Nova Wingate, both as landlord and as tenant. Mr. Moody's signature were on both sides of that contract. The testimony was that Vanguard employees did not typically go to that warehouse and that no one else really had access to it. Further, Mr. Wong said that the machines were worthless. Others said that the machines were worthless. Mr. Gibson testified that he found that the machines were worthless in part because Mr. Moody, who claimed that they had value, never sold them or made any use of them in the multiple years since he contributed to them to the company. Ultimately, they were served for scrap value. Obviously, fraud does not have to be proven by direct evidence. It can be proven by circumstantial evidence. And Judge Conrad found that those items were more than enough for the jury to infer that Mr. Moody falsely represented that those, and intentionally falsely represented that those machines had value as a way of inducing Pai Long to enter into the agreement for Vanguard. He also noticed that Mr. Moody would have had motive to do so, or Nova Trading would have had motive to do so, as Nova Trading's interest was tied to its capital contribution, and that motive alone can sometimes be sufficient evidence for intent with respect to fraud. As to the conversion claim, I understand my friend's argument to be that the directed verdict arguments are sufficient to cover both, as to the specifically identified argument, are sufficient to, I believe, broad to cover both the conversion and the embezzlement claim. With due respect, that's not what the trial counsel, Mr. Moody and the defendant's trial counsel did. He specifically differentiated between the conversion and the embezzlement claim in making his arguments. He says, as to the other claims, specifically on the claim of embezzlement, there is no more than a scintilla of evidence that Mr. Moody or any of the Nova entities fraudulently and willfully misapplied, converted the money of Vanguard. It's not specifically identified either. And as it relates to the claim of conversion related to the laptops of the Moody children, there is no allegation that Bill Moody participated in that in any way. That's transcript page 377. So Judge Conrad said, well, wait, if you were going to make the specifically identified argument as to the conversion claim, I needed to know that. And it was not apparent at the time, the way that those two were divided up. It sounded like you were making the specifically identified argument as to the embezzlement claim. And Judge Conrad then notes that there is no authority, at least as of now, holding the specifically identified requirement exists as to the embezzlement claim because it's not common law, it's a statutory claim. And that the conversion claim arguments were related only to the laptops and the idea that Mr. Moody had not personally possessed those laptops. Plaintiffs try to take a divide and conquer approach by getting into the head of the jury. They say that because the conversion claim was $272,300, or the verdict on it was, that it must mean that the jury added together $232,000 from the expert report for money and credit card expenses that were converted, and $40,000 for laptops, personal property, and cars that Mr. Moody stole from the company. With due respect, and Judge Conrad said this too, we don't know that the jury did that. And to suggest that we know that just because we can reverse engineer the math would violate not only the principle that we liberally construe the verdict to be sustained, but also that we assume that the jury followed the judge's instructions with respect to the statute of limitations. That reverse engineering is also important for their specifically identified or sufficiently identified argument because it's only as to the money that, and as to the conversion claim, that the sufficiently identified requirement would exist. Now, there's personal property, there's a significant amount of personal property that could justify that verdict. Personal property would include the Panthers tickets. Now, there's two ways to view the conversion of the Panthers tickets. One is that they were converted because they were wrongful expenses. The testimony was that the Moody's, Mr. Moody and his family bought on company dollars through credit cards 16 season tickets to the Panthers, which they gave out to family and friends. So you could suggest that was the conversion of money because they submitted those expenses and they were paid back. You could also submit that those were bought on behalf of the company and then converted afterwards. We don't know which one the jury did. There's also a Lexus SUV that Mr. Moody testified was parked. It was a company car purchased on company, titled to the company and purchased with company money that Mr. Moody testified was parked in his garage when asked where it was at trial. And then laptops and phones, which he directed his children who he employed at Vanguard to upgrade and then take with them after they were terminated. So there's a significant amount of personal property that would justify the $272,000. And obviously, if it was personal property, the sufficiently identified requirement wouldn't exist. There's also substantial other amounts, salary and other matters that that Mr. Moody directed to his wife Noreen, who did not work for the company at all. Salary that he directed to the friend of his, or the wife of his friend, Norma Alexander, in a scheme to avoid Social Security, invalidating Mr. Alexander's Social Security, $160,000. Excess salary paid to Moody's children, which was estimated anywhere between $453,000 to $810,000. Now, in the reply brief, defendants suggest that we have mischaracterized Mr. Gibson's expert report to say that he did not, and they say that he did not find that the Moody children were paid excess salary, or that Mr. Moody used his position to pay his children excess salary. That's not true. Mr. Gibson's report, if you read it, says that of the 7 family members that Mr. Moody employed at the company, 4 were paid excess salary. And those, he found that 3 were paid reasonable salaries, and those were Timothy, Christine, and Angela, but found that Noreen, Michael Moody, Mary Kate Moody, and Patrick Moody were all paid excess salaries, and estimated those damages between $450,000 and $810,000. So there are also other bases for the conversion claim other than just the credit card statements. However, as Judge Conrad noted in his opinion, they are sufficiently identified. Variety Wholesaler says that you need to identify the specific source, the specific amount, and the specific destination and funds. It should be important to note that Variety Wholesalers involved a case where the plaintiff had agreed with an accounting firm to transfer money to the accounting firm, which the accounting firm would then hold and disperse to the various vendors of the company. What the plaintiff did not know is that that was a secured account by the secured lender of the accounting company, and the secured lender took the money. Plaintiff then filed a suit saying that the money had been converted. This court said, well, you needed to be able to trace and specifically identify the money that went in to be able to show that the money was converted. We believe we've done enough in this case to sufficiently identify the money. First, Mr. Gibson, and this is at document exhibit 247, identified the specific credit card accounts on which all of the charges were made. He testified that he had examined 1,300 documents, including credit card statements and the company's general ledgers. He identified the credit cards, as I said, on document, that's Doc X 247, credit card accounts. He then there was then testimony that the way the credit cards were paid by the company is that Mr. Moody would give the credit card statements to the company's then CFO, Kristen Wagner, who would automatically pay them in full. And again, plaintiffs have said we took liberties with the record, but that's not true. Transcript page 486 is where Mr. Moody testified that those credit card bills were paid in full. And then they would go through, and he and Ms. Wagner would mark anything that they deemed to be a personal expense, and that would then become a receivable as opposed to marked as an expense of the company. So we now know, okay, we've identified the source. We've identified how they were paid. They were paid out of the company's general ledger. Then we've identified the specific amounts. Mr. Gibson this is Doc X 295 to 298, list every single transaction that he identified as a wrongful personal expense of the company, listing not only the amount and identifying, at least by the individual, the credit card that it came from, but that can be cross-referenced to the earlier part of his reports where he uses the account numbers, but then list the Bates number with the credit card statement or the general ledger entry in which that expense was paid. We believe that's more than enough to sufficiently identify the monies converted. As to the personal property, the assertion was that Mr. Moody did not possess the laptops that his children took, and the cell phones that they took. If you read it through the eyes of the DV argument, that he in no way was participated in it. However, at record page 1585 through 38, or 35 through 38, is deposition testimony which was introduced at trial, where Mr. Moody's children say that Mr. Moody instructed them to upgrade their cell phones, buy new cell phones, upgrade their laptops, and to take them with them when they left. Again, Mr. Moody took a company car, which he exchanged for a new one shortly before being fired, and testified that he had continued to keep it and wrongfully hold it, and that it was parked in his garage. And so there is more than enough evidence there to support conversion. If defendant's point is that Mr. Moody did not personally possess the property, their argument's legally defective. The essence of a conversion claim, and this is Variety Wholesalers, is not the acquisition of the property by the wrongdoer, but the deprivation of it by the owner. Merely the fact that Mr. Moody deprived Vanguard of its property and used it for his own purposes, whether that was for his own possession or the benefit of others, was more than sufficient. As to the embezzlement claim, we believe that there was sufficient evidence also to be sufficiently identified. Plaintiffs don't make that argument as strongly, or excuse me, defendants don't make that argument as strongly there. And in part, it's because they have not been able to reverse engineer the embezzlement claim the way that they claim that they've been able to reverse engineer the conversion claim, because it's for a sum of $500,000, which doesn't directly correspond to any of the components of Mr. Gibson's report. I would suggest the fact that the jury followed Mr. Gibson's report in some places, excuse me, but varied from it in others, is all the more reason to assume that we cannot assume it's math or completely reverse engineer what the jury knew. Finally, they suggest that the conversion claim, there should be a new trial or remediator because it's necessary that the jury, or it's a necessary conclusion that the jury disregarded Judge Conrad's instruction not to consider damages outside the limitations period. And again, this relies on supposition. It relies on the supposition that the jury's $272,300 award for conversion, which again does not correspond to any specific item in Mr. Gibson's report, is the product of adding two items, the $232,000 for money converted through the credit cards and $40,300 for their personal property. Judge Conrad said that goes too far, that doing that making that assumption would violate the presumption that the jurors were presumed to follow the court's instructions, and that the verdict should be liberally construed to the view toward sustaining it. He noted that there were other matters presented that would support the conversion claim. And again, those are salary directed to Noreen, salary directed to Norma Alexander, excess salary paid to the Moody children. There were evidence of checks. This is Doc X 310, 336. Checks written by Mr. Moody to Nova Trading without authorization. There were laptops and phones, and there was the Lexus SUV. So there were other items that could have been, excuse me, the Lexus SUV would have been in the $40,000, but there were other items that could have supported the conversion claim as well. And we don't know whether the jury came to its conclusion merely by adding those two items from Mr. Gibson's report or estimating many of the other items that were asserted as claims. Finally, as to the dissolution point, and Mr. Odom noted this at the end, he said that really the Exhibit A for their dissolution is the jury's verdict. The dissolution, as we heard even in the case before us, by statute is authorized when it is not practicable to conduct an LLC's business in conformance with the operating agreement and the LLC Act, or liquidation is necessary to protect the rights and interest of a member. There's another reasoned opinion and a separate opinion that Judge Conrad entered on August 31st, 2022 on the motion to dissolve, in which he said that in which he noted first that defendants had not, Nova Trading had not submitted any evidence whatsoever to support a dissolution claim. The only evidence it attached to its brief was the operating agreement itself. Contrast that with the case Your Honors just heard, where there was affidavit testimony, deposition testimony as to the transactions and the other items involved. And he said that reason alone would be enough to deny the motion. But he said it's not impracticable for the LLC to do its business. First of all, there is no deadlock, nor can there be. Pai Long holds a 67% interest, and Nova Trading holds a 32% interest, and there are decimals behind that, but all of which was stipulated at trial. And it is not necessary to protect Mr. Moody's interest or Nova Trading's interest. The operating agreement requires that Pai Long get Nova Trading's consent before adding members, amending the operating agreement, or selling the company's assets. So there are sufficient protections. Yes, Pai Long holds the majority, but that is what Nova Trading bargained for.
Let me make sure I'm understanding your argument, and I will phrase your friend's argument, and hopefully I've got it right. I heard at least that he's concerned about a potential fiduciary duty situation. Is the argument you're making now is that when you say protected, they're protected so that fiduciary obligation would be upheld?
Yes, Your Honor, I think generally. I mean, I think that the point is that there are sufficient protections for the minority member, for Nova Trading sitting as a minority member before certain fundamental transactions take place, so that so that there has to be consent among all members. And so while there may be certain operational decisions that are made by the majority member and that he would obviously lose out on if it came to a vote, that as to certain fundamental transactions, he's protected under the operating agreement. And there's been no suggestion that any of those have been violated either. So it's purely supposition that because there's acrimony between the parties, or that there's a judgment that Nova Trading now sits in a position where it would have its rights violated, but there's no evidence that that's occurred. There was evidence at trial that there had been no distributions, but as Judge Conrad noted, the evidence was not that Pai Long had been making distributions to itself and not to Nova Trading, that it simply had not been making distributions at all to any of the members, and that alone was not enough to support dissolution. The final point that Judge Conrad made in his order denying the motion for dissolution was that doing so would really violate and run at odds with the jury's verdict. Nova Trading asserted claims for violation of fiduciary duty at trial, claimed that Pai Long had violated fiduciary duties with respect to it, and the jury rejected all of them. And so if that was to be the basis for dissolution, the jury found that it didn't exist. In sum, and I'm welcome to answer any questions, we simply believe that the arguments that the defendants are now making to you were not preserved, as Judge Conrad noted. But even if they had been, there was more than sufficient evidence at trial to support the jury's verdict and to submit these issues to the jury, and for the judgment to reflect the verdict. And we believe that Judge Conrad's order should be upheld. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Chief Justice Newby. Just a couple points to follow up on that were raised in the appellee's argument. With respect to the argument about the equipment or the inventory that was brought in by Nova Pai Long and contributed at the beginning being in this warehouse, the testimony was that everybody knew about this warehouse. It was actually the warehouse from which the parties had operated before the formation of Vanguard Pai Long. So it wasn't like it was this hidden offsite place where no one knew about and was secreted. That's just simply not the case. Also, Mr. Moody testified at trial that indeed parts were sold from that initial capital contribution or used. All of them weren't, but over time they were. That's pointed out in our brief in his trial testimony. And so this wasn't just equipment that was placed on mothballs and not used at all and kept from inspection or use. With respect to the Panthers tickets, there was testimony that actually 4 of those tickets in the PSLs were owned by the Moody family themselves. And so Mr. Gibson in his report actually lists 8 sets of tickets. 4 of those were actually the Moody's. There was also testimony that employee raffles were held for people to win tickets to go and use for the company, employees of Vanguard to go use those tickets at the Panthers games. And really, it's the expenditures that for the tickets that Mr. Gibson in his report identifies. It's not the actual physical ticket being converted. It was the expenditures for those tickets that they said was a conversion of funds versus the actual, I'm going to the Panthers game, I have a ticket, I'm converting it because I'm using it to go to the Panthers game. That conceptually wasn't what their request for damages was. It was expenditures and funds. We also believe, again, under the variety wholesalers, that the citation of dates where expenditures were made and for what they were made is not sufficient. And we don't know whether they're talking about the actual credit card charge that was made to purchase tickets, or if it's the reimbursement after the fact or the payment of the credit card. So yeah, there's a credit card transaction pays for Panthers tickets. Are we talking about that? Are we talking about Vanguard then paying the credit card? And what about reimbursements that happen on the back end once the Amex card was paid and then they're expensed, and then there's money that goes back to Vanguard, because that was the process. They would pay the credit card, Vanguard would pay the credit card, so there wasn't charges, and then would reconcile based on any personal expenditures that were made on those cards. And so we don't know what that is. With respect to the allegedly excessive salaries, it's interesting. There's testimony and documentary evidence that both Mike and Mary Kate got raises by Vanguard after Mr. Moody was fired. They actually each got a $10,000 raise towards the end of their employment from November 17 until they were let go in May of 2018. Mr. Wang actually approved raises for them. So to suggest that they got salaries not commensurate with their positions is belied by what happened that Mr. Wang approved. With respect to the judicial dissolution, I agree there wasn't evidence presented attached to the motion to dissolve, but Judge Conrad sat over the trial. He heard all of the evidence, and that's part of the benefit of being the trial judge. You don't have to attach a transcript to cite the trial judge to evidence when the trial judge actually heard the evidence. And so we don't think that there was a violation of any briefing rule by not attaching a transcript that isn't necessary in the first place because the judge heard the evidence. And lastly, I would say, with respect to judicial dissolution, it would ask this court to recognize that it's not a static situation. And so if there is an affirmance of the denial of our motion for judicial dissolution, that it be without prejudice to be able to bring another motion for judicial dissolution, either in this action or another. And just to point that out, because again, this is a tenuous situation with a business where the majority and minority owner are clearly at odds. Appreciate the court's time. If you have any questions, I'll answer. Otherwise, I see them at my close.
Thank you, counsel. Thank you
Thank you,
both.
Your Honors.
Mr. Clerk.
All right.